So today we are going to go through the latest amendments to trademark law, and that includes the trademark different stage of your trademark, including the registration stage and how to use your trademark in a proper way. And the topic that everyone concerned about face registration, is there any new rules about it? And lastly is the enforcement of the trademark rights. And how will the new trademark law affect EU SMEs like all of you today in the webinar? And what adjustments is required before the 1st January 2027? But before we go through the new law, let's make sure everyone knows the basic of trademark law in China that applies not just for the new trademark law, but also in the past 20-30 years. So there are 3 basic principles you need to keep in mind. First is registration. That means if you have not registered your trademark in China, either you only have a trademark registered in Europe, or you only file a trademark in China, but it's not registered yet. You do not have the full protection in China. You have to wait until your trademark register in China to get the full protection. That means you can enforce your rights. That means you can safely use your trademark in China. So the time is essential. We always recommend you to file and register your trademark in China as soon as possible. Second, trademark right is territorial rights. Again, if you only have trademark in Europe, you cannot use your European trademark to defend yourself in a litigation in China, or you cannot use that European trademark to ask someone else to stop infringing your rights. Making sure you have the trademark right in China. And the third principle is first to file. I believe a lot of you already heard about this principle. If you are not the first one to file your trademark in China, someone else may do so. That's highly likely it's bad faith registration. And that is also the reason why bad faith registration is so common in China, because instead of the first to use principle, first to file, whoever is the first to file the trademark and have it registered, they can claim they are the trademark owner, and they can claim they have the rights over those trademark and stop someone else, even you as the authentic owner, from using trademark in China. And the life cycle of trademarks in China are very similar with the European one. So first step, it's always you create your brand name. Because it's in China, we use totally different language. It's Chinese. So instead of except for the Latin name for your brand, you should also consider a Chinese brand name. And when you consider the Chinese brand name, you have to do it early as possible and come out with many candidates as possible. You can design your trademark name in Chinese according to the pronunciation or the meaning, but the pronunciation is more common in China. That's easier for the customers to remember what's your brand name and pronounce it in a similar way as your Latin name. Second step is trademark search. So you should check if there's any similar prior mark already registered in China. If you skip this step, it could be a big waste of your money trying to get your trademark registering in China. In China, every year there are 5-6 million applications filed with the China authority. So the chance for Latin brand names, sometimes including only 3 letters, to encounter similar trademark, it's very, very high. So the trademark search is very essential before any protection. And also check if your mark can be registered. That means if your trademark includes any misleading element or any deceptive elements, which we are going to talk about it later. Avoid this red flag can make your trademark registration more smoothly. And then it's the third step is apply for a trademark. You can choose national route or international route. National route means protection only in China. International route means you can file an international trademark covering China and other places such as US, EU, Japan, Singapore, all those member states. And if you choose to file nationally, then you have to hire a trademark attorney. If you choose the international route, you don't have to hire a trademark attorney in China at the beginning. However, if your trademark being refused, then a trademark attorney is required. It's not just recommended. And generally speaking, it takes 7 to 18 months to have trademark registered in China. After the registration, which is post-registration stage, you should pay attention to how to use your trademark. And the new amendment puts a lot of focus on the use of trademark. Therefore, it's important to understand how to use your trademark properly. Firstly, how to use the R logo, which means registered trademark logo. It has to be identical with the mark you register. And also, you should keep the evidence of use regularly and in a systemic way. We also will talk about it in details. And the trademark is valid for 10 years. And after 10 years, you can renew it for unlimited time. If you want to, your trademark can live for 100 years in China or more than that. If you don't want to, you can stop renew it after 10 years and your trademark will disappear in the market. So the fifth amendment to China's trademark law. This is the fifth time of amendments. It will come into force on 1st January 2027. That leaves us about 4 months to get ready for the new law. And it shifts from the emphasis on registration towards the obligation to use. One of the concern is the bad faith registration, because a lot of bad faith registration, they do not the registrant does not have the intention to use. Hopefully, the amendments can reduce the bad faith registration by shifting this emphasis. And if we look at the major change of the amendments, it covers new type of trademarks, it shortened the opposition periods, also introduced new measures against bad faith registration. It protects the unregistered well-known trademark, also introduce new valid evidence of use, also the measures against bad faith registration. So firstly, let's see during the trademark registration stage, what kind of new change we need to pay attention to. First is there's a new type of trademark, motion mark. Now it can be registered as trademark in China, but even now, I mean, today, if you try to register motion mark, it's not available. You have to wait until 1st January of 2027. And motion mark is one of the non-traditional trademark that use animation or movement to identify a brand. It's been in EU since 2017, 10 years ago, and other non-traditional trademark in China includes 3D mark. For instance, like the drawing of 3D of your shoes, of the perfume bottle. That it's the 3D marks. I will have to tell you that 3D mark, even though it's allowed according to the current trademark law, but it's still quite difficult to get one. Theoretically, it's available in China. And another non-traditional trademark available in China also include color combination mark. However, scent mark, it's not one of those non-traditional marks that are available in China. Motion mark, 3D mark, color combination mark, all right, but scent mark, it's not possible. Just an example of motion mark. Like if you watch movies, especially in theater before, you definitely can identify the Columbia pictures. That is the dynamic opening sequence featuring the torch lady. It's the woman holding a torch at the beginning of all of its film. So when we watch that torch lady video, we understand that it's connected to Columbia pictures. And another one, if you are a football fan, you can identify is the cross-arm celebration gesture from Kylian Mbappé. And he registered his trademark of this very specific celebration as motion mark in EU IPO. So, except for, sorry, one thing I need to mention about the motion mark is if you are in the creative industries, such as multimedia or video games or fashion and design, music, performance, or even marketing, you can consider to register motion marks in China next year, of course. And the second update is the rule of deceptive trademarks. It has been stricter. So the amended trademark law introduced stricter punishment for deceptive trademarks. What does deceptive trademarks mean? And in what situation it will be deceptive trademarks, including those trademarks that are deliberately designed to mislead consumers, or those trademarks induce erroneous perceptions as to the quality, manufacturing process, raw materials, or place of origin of the goods. Very simple example, like if your trademark is if your product is about Greek cheese, but somehow in your trademark you mentioned about Milano, because Milan is not part of the Greek, so this is misleading trademark because it misleads the consumer of the place of origin of the cheese. So that is the deceptive trademarks. However, in practice over those years, it's more and more common for the trademark to facing this problem of being regarded as deceptive. Even in a lot of occasions, we think it's very unfair. For instance, what I heard is a trademark including bamboo. They were trying to register in furniture industry, but their trademark is not just bamboo, it's like bamboo panda or something like bamboo fruits. It's more like just the name just part of their brand. When you see bamboo panda, you will not think all this furniture is made out of bamboo. However, the CNIPA still think in this situation it's misleading. So according to the deceptive grounds, they refuse the trademark registration. This is just an example of deceptive trademark. If a trademark is considered deceptive, the CNIPA will refuse to register it. And it's not just about refusal of registration. We already mentioned that the rule becomes stricter. So as of 2027, a fine of up to 5 times the illegal turnover may be imposed if trademark is deemed deceptive. Whether or not your trademark is registered, as long as it was regarded as deceptive, you will have to face the 5 times of the illegal turnover. Furthermore, if your trademark already registered, later on it was considered deceptive, then your trademark may be invalidated. That means your trademark will be removed from the markets. And because now everyone can report deceptive trademarks, your competitor has the chance to report to the CNIPA that your trademark is deceptive, and then the CNIPA will look into it and decide whether or not it's deceptive. So this is so for EU SMEs, we highly recommend it to go through your trademark portfolio and ask an IP expert to give you professional advice to see whether or not your trademark is proper in China, whether or not it's registered. And another important amendment impacting EU SME is the fact that the term of trademark opposition has been shortened from 3 months to 2 months by the new law. Why is it important? Because as you can see, the opposition period is shorter for EU SMEs. If you face this deadline, most of the time it's you or your IP expert identify bad faith registration in China, and you can file a opposition against it. Now, in 2027, you will only have 2 months to react instead of 3 months. Therefore, you have to react faster to oppose the trademarks. And if you were filed against, if your trademark is filed against this was filed by your competitor or anyone else in the market who try to file a similar trademark like yours, you also have to react fast, even though you are the defendant. In any situation, a local trademark attorney is recommended, and you should have a local trademark attorney in place even before you file an opposition or receive a notice of opposition. And talking about the trademark attorney, there are new regulations of trademark agency. The revised trademark law strengthened the regulation of trademark agency and law firms by extending prohibited conduct, including soliciting business through fraud, deception, and also disparagement of other trademark agency, and including other improper means. And if the trademark agency does conduct any of this behavior, the CNIPA can impose increased fines to the trademark agency or temporarily shut down the trademark agency. So you do not want to work with the trademark agency that has some illegal actions. And this new regulation should help the SMEs to increase the confidence when selecting the trademark agency in China. And I have been asked by many SMEs how to find a proper trademark attorney. You can always refer to our external experts list, which is the first QR code here. We work with those experts in Europe as well as in China. And we know their expertise, we know their professionalism, so they are trustworthy. And you can also refer to our step-by-step guidance, as well as the video to find an IP agent. And if you want to verify the IP agent you're working with, you can go to the CNIPA database, input the trademark agent's name or trademark agency's name, and you will see whether or not they are recorded with the CNIPA. If they have not recorded with the CNIPA, you shouldn't work with them. Keep in mind that those databases only in Chinese. If you cannot navigate this Chinese database, you can always contact me and I will do it for you. I will verify your IP agency for you. And next change is about well-known trademark protection. Well, in the past, for a well-known trademark protection, if it's not registered in trademark, the protection is very limited. However, the new law extended to provide cross-class protection to unregistered well-known trademark. Just an example, Haagen-Dazs, an ice cream company, an ice cream brand, they are well-known trademark in China. If a Chinese company registers Haagen-Dazs as a brand name on clothing, which Haagen-Dazs have not registered on it, can this Chinese company register it? According to the new law, no, they cannot anymore, because cross-class protection cover the unregistered well-known trademark. Even though Haagen-Dazs have not registered in clothing in China, but it's a well-known trademark in China, so it updates full class protection. However, from what we observe, very few EU SMEs brands achieve the well-known trademark protection. It requires years of branding and use in China, and it's just very difficult to be acknowledged as a well-known trademark, not just for EU SMEs, but even for the big companies. And the above, it's about the registration application stage. It's more about the procedure. Now we will talk about post-registration stage, how to use your trademark properly in China. And why the use of trademark is important? Because like I mentioned before, the new amendments put a lot of focus on the intention of use. The CNIPA want to make sure every trademarks will be used after they register it. And That means EU SMEs need to provide some evidence of actual use or at least a business plan when registering trademarks in China. And other than that, use evidence is also required in enforcement proceeding or in non-use cancellation or opposition and invalidation proceeding. Those use evidence is helpful to present before the CNIPA or the court that you have used your trademark and your customers cover a lot of provinces or a wide range in China. Therefore, the other similar trademarks should not be registered because that will cause market confusion. It's just an example of why and how you use your evidence of use in this conflict situation. And additionally, if any goods or services are not relevant to the business, the trademark registration might be refused by the CNIPA. This change might have an impact on the defensive filing strategy. A lot of you might have heard about the defensive filing. What is that? When initially filing for trademark registration, a trademark holder might consider also registering defensive mark in potentially relevant classes, such as if you produce or manufacture this coffee, and you may also considering registering in beer or in snack because they are still part of the food and beverage classes. And this can help you to prevent future confusions by other, especially like Buffet's registration. They file in similar classes. And then later on, if you try to extend your business to other classes, you find yourself cannot because someone else already did it. That's part of the defensive strategy. And a broader defensive strategy is filing all 45 classes in China. That's from first class to the last class, 45 classes of goods and services. That strategy used to be very, very common for big companies. And now company has to consider, because if they file 45 classes, the chance you use in 45 classes are very low. So you have to choose to file in certain classes which has the business commercial value. Otherwise, you might be categorized, or your trademark might be categorized into this malicious registration without intent to use. Just an example. Again, it's a food and beverage company. If you plan to do R&D in China, not now, but in the future, you want to develop your recipes in China, then you can consider to file in Class 9 R&D. And if you plan to promote your foods in Alibaba or any other online shops, or you want to have your own online shop, then you should also consider Class 35 marketing. Class 35 is always very popular because for most of the company, if you want to be retail or wholesale in China, then this class is essential. However, for this food and beverage company, if they want to defensively file in Class 5 drugs, which require very high license, and this company, food and beverage company, apparently they do not have, and in short term they cannot have, then this defensive filing is a waste of money because highly likely your trademark will be refused. Similar situation if this food and beverage company want to register in Class 18 covering tote bag, which they do not have the business plan at all, then this defensive filing might not be refused as well. Therefore, as an SME, if you need defensive filing, then you should consult a legal professional before filing any of the trademark. And for any business, you should regularly review your trademark portfolio, distinguish between the core trademark, which means you are using this trademark in China, and from core trademark from defensive registration. And defensive registration, you should distinguish whether or not it has the commercial purpose in the future. If not, then you might not. You will. You might not want to file it. Just avoid waste of your money. And besides of the defensive filing, we also see the new valid evidence of use. Why is it new? Because the internet use evidence now has been included in the valid evidence of use. What kind of evidence included? Those evidence on social media, web page, or e-commerce platforms. That's in line with the faster development of digital economy in China. And the sources from social media, web page, and e-commerce platform now be treated as evidence of trademark use in China, and that make it easy for EU SMEs to prepare either to prove the intention of use during the registration procedure or support the use evidence in enforcement proceeding or in non-use cancellation proceeding, which I will go into later. And for the companies, you should establish a systemic trademark use record keeping system, including the traditional documents, which are contracts, invoices, or payment records, and advertising materials. Those are the traditional one. And besides that, you should also preserve the digital proof, such as website screenshots, social media post logs, live stream recording, e-commerce products page captures, logistics records, e-commerce transaction records, and backend order data. As many as you can think about, they are digital proof. And because they are digital proof, the authentication always can be challenged by the authority. So how can we avoid being challenged? You should apply timestamping or other blockchain-based technology. They are used to certify the online evidence. And we already talked about the evidence of use, and it's very important to have the intention of use after the trademark registration. We also mentioned about non-use cancellation. What is non-use cancellation? That is a challenge action that anyone can raise against a registration after it is registered for 3 years. If your trademark has been registered in China for 3 years, someone may challenge your actual use of this trademark. If you cannot provide any evidence in China in the past 3 years, usually the valid evidence, including OEM evidence and the sales evidence and online evidence we just talked about. If you cannot provide any of them, then the authority will assume that in the past 3 years you have not used your trademark and your registration is a waste of resources. So the authority can cancel your trademark and give this opportunity to another company. And what has been changed? Now trademark use can be challenged not only by the third party, but also by the CNIPA. In the past, CNIPA was too busy to go through all the use of the trademark, but now, since the intention to use is so important, so they will proactively check whether or not your registration has been used properly. That's one change. Another change is the restriction application scope of the 1-year bar period. So the new law regulate that a trademark registrant applies to remove its registration application, then the CNIPA shall not approve any trademark application identical with or similar to this removed trademark filed by others for identical or similar trademark within 1 year from the date of the publication of the removal. What does that mean? That means, for instance, you have a trademark called like Apple, and you decide you don't want to use it. So you tell CNIPA that I don't want my trademark anymore. I want to remove it from the registration list. But out of the respect of your trademark in the past registered years, within 1 year after the removal of your Apple trademark, any trademark called Apple or similar trademarks like Apple A, Apple B are not available, cannot be registered in China. This is a protection period of your previous registered trademark. And in the past, this 1 year bar period does not only apply to the removal trademark, but also apply to cancelled trademark, or the trademarks being invalidated, or the trademark which is not renewed after the after a certain period. The 1 year bar period apply to this. However, with the new law, the 1 year bar periods will not apply to any of the situation anymore. It only applies to the removal trademark. For SME, why is it important? That means you should, first of all, you should regularly or yearly preserve evidence of genuine commercial use to defend yourself in non-use cancellation. Secondly, keep in mind that once your trademark is cancelled, you don't have the 1 year bar period anymore. Someone else can file similar or identical trademark immediately. So you should, if you still want your trademark in China, you should react to any non-use cancellation as early as possible. And next, it's about bad faith registration. I know all of you is concerned about it. And bad faith registration is a trademark filed by a Chinese entity or an individual registering foreign trademarks in China first with the intention of gaining money from transferring trademark back to the real owner, most of the times foreign companies. And especially when the foreign companies try to enter the trademark market, they are in urgent need of trademark right, but they cannot register a trademark in China. In this situation, a lot of foreign companies would like to pay fortune to get their trademark right. It has been the biggest issue for EU SMEs for a long time. And each year, we Helpdesk receive many inquiries from SMEs whose China market entry has been blocked by bad faith trademark registration. Although the Chinese authority have taken steps to curb bad faith registration, the issue has persisted. While bad faith registration were already banned by the 2019 Trademark Law amendments, which is the fourth one, the last one. The new amendment introduced even stronger deterrent to those bad faith registration. And according to law, well, there are different articles related to the definition. There are different types of bad faith registration, including the identical or similar mark copying from prior brand, or the trademark which were filed with the intention of holding by the registrants, especially for those trademarks in foreign language, and the trademark filed without intention to use, but targeting trademark squatter, and those trademarks filed by the agents or the OEM manufacturers or distributors out of bad faith to take the advantage of business partners who has not registered trademark in China. And there are different strategies to fight against the bad faith registration. You can choose to oppose it. You can choose to file a non-use cancellation or an invalidation against it. This is the comparison of different strategy. And I was asked by many EU SMEs how to take reactions against it. Here's the comparison. I will not go into it. We are going to share these slides with you after the webinar. So feel free to use these charts and to assess which option is the best for you. You can also ask me whether or not this option works for you. And besides those challenged petition you can file with the CNIPA, you can also try to talk with the trademark owner to see whether or not they can assign trademarks to you. However, we do not recommend you to talk with the trademark registrants right away because it's too risky. They could file multiple trademarks after you approach them. Then it will be even more trickier for you to handle. Always have an IP expert to handle trademark assignment. And after the assignment, you have to record it with the CNIPA before the trademark owner switch to you publicly. So again, this is not a simple option. Have an IP expert to handle this situation. And if you already handle these trademark conflicts in Europe, you may know letter of consent or coexist agreement. Unfortunately, the CNIPA has not accepted the letter of consent since 2021. This is very different practice in China. However, if you go to the courts, it's more flexible. Or another option is you can try to rebrand in China and maybe come out with a Chinese brand name or just change your mark in China for goods. That happens to many brands in China, even the famous one. And then what is the new rules against bad faith registration according to the amendments? Starting from next year, the CNIPA could order the bad faith registration with a fine up to around 100,000 RMB. It's around 13,000 euros. Previously, right holder could only resort to opposition or invalidation or non-use cancellation against the bad faith filing. Or you can go to the civil laws. But if you have not used your trademark in China, it's really difficult to win this bad faith registration challenge. And the amendments enable right holders to file an administrative complaint as well, as long as the registration was made in bad faith and has produced adverse market impacts. Usually, if they mislead the consumers, it can be included in the adverse market impacts. So it might be easier if as a real rights holder to remove the bad faith registration. That remains to be seen, because that's a huge change in practice. And if that actually works, that will be much easier for the trademark owner in Europe to remove the bad faith registration. Therefore, for SMEs, we hope to see less bad faith registration in China. However, that doesn't mean you don't have to register trademark in China. Our advice remains the same. You should register a trademark in China as early as possible. This is just a case study of the bad faith registration we received from an EU SME who is in the makeup cosmetic industry. So this company tried to register their trademark in China. However, they found a bad faith registration. Why is it bad faith? Because this trademark registrant, they owned over 90 trademarks, and this is an individual, so the number is it's very obviously beyond their ability to use trademarks in a commercial way, and more than half of those 90 trademarks were copied from foreign brands. So the EU SME filed a request for assignment after signing an assignment agreement with the trademark scorer. They decide to go in an amicable way. However, the CNIPA requests the evidence of use from both assigner and the assignee, and the SME provide proof of use in their Chinese online shop. However, the trademark scorer has no evidence of use to provide because they did not plan to use it at all. And the CNIPA refused the assignment because the insufficient proof of use, especially there's no evidence from the trademark scorer. And they also confirmed the bad faith of the trademark scorer. And the CNIPA refused to assign any bad faith registration even to the authentic trademark owner. That's why, like I said, if you want to solve your bad faith registration situation by transferring your trademark, you have to have IP experts have an IP expert support you. And trademark assignment might no longer be an ideal action to overcome the malicious trademark. And before the assignment, you should run a background search to see if the seller has bad faith. And you should consider different other challenges actions, including opposition, non-use cancellation, invalidation, and nowadays an administrative complaint. Always preserve the evidence of use of your brand in China. Now online evidence is available as well. And register your trademark in China as soon as possible before you found out any bad faith registration. And the last major change is the new amendments has the intention to crack down on bad faith litigation. The bad faith litigation has been refined by the new amendments as well. It was defined as two specific categories: malicious collusion and fabrication of basic facts unilaterally. A very typical example is the bad faith registrants. They file a lawsuit against authentic trademark owner because they have the prior trademark right in China. Theoretically, yes, they can file the lawsuit, but according to the new law, this is bad faith litigation, and the bad faith registrant has to bear civil liability according with the law. They need to cover the losses they cause to the authentic trademark owner, such as the lawyer's fees caused in the litigation or illegal turnover. That also again shows the intention or the emphasis of cracking bad faith registration by the CNIPA or by the Chinese authority. Lastly, some takeaway messages. For trademark right in China, no registration means no protection in China. It's important to do trademark research before the registration to avoid being labeled as deceptive trademark. And you should be more careful about the defensive filing, and also regularly preserve physical and online evidence of trademark use. If you encounter bad faith registration, you have many options to update trademarks right in China, but always consult the IP lawyer and experts in China.